Justice Clarence Thomas broke a decade of silence in one of the first sittings of the U.S. Supreme Court after the death of Justice Antonin Scalia. In the Voisin case pending before the courts, Assistant to the Solicitor General Ilana Eisenstein was defending an expansive application of a federal law that imposes a lifetime ban on one's right to keep and bear arms upon conviction of a misdemeanor crime. Mother Jones reported that there were audible gasps in the courtroom when Thomas's booming voice asked counsel for the federal government if she knew of any other example where a misdemeanor criminal conviction could deprive an American citizen of a constitutional right. The lawyer for the government, reported Mother Jones, was completely stumped. Following up, Justice Thomas asked if one's First Amendment rights could be taken away from a person upon a conviction of improperly publishing something about children. Knowing that there was no such precedent, the government lawyer tried to escape Thomas' question by lamely suggesting that one's Second Amendment rights could be restored by a pardon, a rare occurrence indeed. Justices Kennedy and Breyer joined the exchange. Realizing the weakness of her argument, the government lawyer finally took the position that the question was not raised by the parties and therefore was not truly before the court. But as the Mother Jones reporter observed, Justice Thomas' question had been taken from an amicus brief filed in the case by Gun Owners of America and Gun Owners Foundation. And as the Mother Jones reporter further noted, Justice Thomas' questioning completely changed the tenor and direction of the argument. This was not the first time that Gun Owners of America and our other clients have raised this same issue, having first pressed it in a case in 2010, addressing the constitutionality of the same statute in the U.S. Court of Appeals for the Seventh Circuit. Our argument was ignored then, but it now has resurfaced in dramatic fashion 6 years later, and gaining notoriety because Justice Thomas selected this issue to break his practice of not asking questions during oral argument. Whatever happens to the gun rights issue in this current case, it is now sure to be raised by the parties in future Second Amendment cases. And the American people will discover that, indeed, no other constitutional right secured by the Bill of Rights to all Americans can be taken away from any person for having been convicted of a mere misdemeanor. Such rights and privileges may be voluntarily surrendered, but they cannot be forcibly denied by the federal government.